Welcome. My name is Russell Lamberti, Chief Economist here at Sakeliga, and I'm joined by my colleague and CEO, Piet le Roux. We're going to give you a very important litigation update today. There are so many important developments in Sakeliga's litigation sphere that we need to share with you today. Sakeliga is currently spearheading by quite some distance the most comprehensive economic litigation in the public interest that's ever been seen in this country. And we're going to talk about some of the highlights of that today. And then also, if you stick around to the end of the conversation, we're just going to finish by telling you what is currently in court, what we're going to be launching soon, what's under investigation for us to launch in the near future, really giving you a good wrap-up of what we are doing from a litigation perspective. Piet, welcome. Very good to have this conversation with you again. We recently helped break a very important story, which has traveled far and wide and garnered a lot of attention, and it is around land expropriation. We are very involved in countering the Expropriation Act. This particular act of expropriation took place first in 2019 in a piece of ground in Boksburg, which is Johannesburg, east of Johannesburg in the metro of Ekurhuleni. This has garnered a lot of attention. Piet, why is this so important, and why are we involved in this story, even if we're not involved in the actual case itself, and how does it pertain to our litigation? I think we need to unpack this for people to really give clarity on what's a crucial issue of expropriation.
Well, what's at stake, Russell, is whether expropriation in South Africa will happen at market value or not. In the case of Ekurhuleni, the City Council took a political decision and said that they want to test the constitutional application of the property rights clause in the Constitution, and they want to put it to the court that there should be a compensation, zero compensation for that expropriation. Companies try to stay out of the news, and so it's for several years it was attempted to settle this amiably and in other ways, but now it's finally going to mediation and sit down for an 18-day trial next year. Why it's important is if the nil compensation decision is not reversed, we're looking at the restatement of assets on balance sheets across the country for development companies, for privately held land, all land that could conceivably also be expropriated in the public interest or for social housing would have to be reassessed, and that means something for the balance sheets of every business and private people, pension funds, everybody in the country. It's very important, so that's why we're looking at it.
So, Piet, for context here, there was an act of Parliament passed in 1975 that essentially covered the domain of state expropriation and the circumstances under which it may or may not expropriate. That has now been superseded by the 2024 Act, although that Act has not come into full operation yet. So we're in a little bit of a transition phase. But of course, that Act is an Act that we're going to be taking on through litigation. We oppose it. We think it's harmful and leaves far too much scope for abuse. Now, a lot of people are pointing out that this case in Boksburg happened under the 1975 Act, and therefore it's not really relevant to the 2024 case. Help us discern what really is at heart in this Boksburg case. Is it the 1975 Act, or is it perhaps something a lot more core and significant, which really pertains to the Constitution? It's really a constitutional question that's up for debate here.
Absolutely, Russell, and that's why we are so interested, Sakeliga, in this case, because we will involve the facts of the Driefontein matter in our upcoming litigation against the 2024 Act. Now, this did happen under the 1975 Act, and the 1975 Act still has some protections for compensation at market value. That's part of why the owners, the former owners of Driefontein, have a good case for obtaining compensation. But in anticipation of this, in understanding that the 1975 Act is actually an obstacle to the public interest zero compensation advocates, the Ekurhuleni Metro Council has now brought a counterclaim. Not now; it's as part of the proceedings. It's involved. They're bringing a counterclaim to have the 1975 Act declared unconstitutional and they make a direct appeal and say they're asking the court to find that the Constitution provides for expropriation as nil compensation in the public interest, and that this case would qualify for that. So that's why we're bringing the facts of this matter into our expropriation 2024 litigation, because we want to show the court that the protections of the 1975 is actually necessary, and we want to show the shortcomings of the 2024 Act. If this happened under the 2024 Act, it would have been much more difficult to challenge.
Okay, so in the first instance, this case is really a test of that famous Section 25 of the Constitution,
yes,
and whether or not it in fact permits instances of nil compensation in cases like we're seeing, where a private landowner is deprived of tens of millions of rands of value.
It's not the definitive test, but it is a test.
It is a test.
And it's a very important test. It is the most important test right now.
Yeah. And as part of this, it looks forward to our case, which is separate from this Ekurhuleni case, which tackles the Act itself, the new 2024 Act itself. Yes. And our claim, is that the 2024 Act strips away important protections for property owners. Some of that is being revealed in this current case, that even under the 1975 Act, and the way that the Ekurhuleni have dealt with this is potentially not sufficient protections, but certainly under the 2024 Act, too many protections have been removed.
Yeah.
And so that's important.
We're bringing our case against the 2024 Act sometime in the next month or so. And I think let's have another discussion at that time where we'll delve into the arguments against the 2024 Act, what the shortcomings are, and what we think we think we have a good chance of success against that. But there are political implications in this case, and so there are no guarantees in litigation of this kind. But we're bringing that case because we think it has to be brought, because we think it has a good chance of success.
And at that point, it might be good to bring in our technical legal expertise and really try and delineate the differences between the old and the new acts, because there's some contention about this, and so people can look out for that in the near future. Okay, Piet, that's nice and clear. Let's move on. Another huge issue where we've actually gotten a recent court judgment on is the Employment Equity Act. This is an update from the original act that was passed in 1998. It's been amended a few times, the most recent amendments, and then the regulations on top of those amendments have, for the first time, have in an extreme way forced businesses to run their hiring decisions on a race-based and gender-based and disability-based spreadsheet that sets 5-year targets down to the decimal point, regardless of location, type of business. As long as you've got 50 or more staff in an organization, the state wants you to be subject to this spreadsheet hiring system. We've taken, Sakeliga took that on an urgent basis to have those regulations set aside while we undertake the more substantive portion of the case, which is to challenge the case in its substantive merits. The High Court, the North Gauteng High Court, refused our application and gave a judgment unfavorable to Sakeliga. What are we doing, and what have we done, and what are the next steps there?
Yeah, together with our partners, NIASA, the National Employers Association of South Africa, we are firmly committed to fighting this Employment Equity Act, this spreadsheetization of society, until we win. This is our position. We will never accept it, and to the extent that it gets implemented, and that we don't right now or immediately or at some point not succeed in preventing every application of it, we will not stop until we reverse every element of it, because it is impossible to have a flourishing economy with that act, and to the extent that act is in operation.
It's unconscionable and unacceptable social engineering on your business. Yeah. It's no way to not only live, but certainly not to do business. And no one hires like this in the real world. This is just not, it's got no connection with real world business practices.
Yeah, thankfully, it's so outrageous in law and in what it purports to require, that there's a good chance of just not that there's a good chance that at some point it'll be reversed and that it will never be fully implemented. Our argument in part is that it is impossible to implement. It is impossible. The skills distribution doesn't exist in the country, and the amount of coordination for this is not possible. It's not possible for companies to comply with this. To the extent that one company does succeed, it makes it less possible for another to succeed. And so that means a good thing. It means we have safety in numbers. Mm-hmm. So we expect most of the companies with 50 or more employees in this country not to be able to comply. And there's also the international dimension. As with the expropriation case, this makes no exception for international or local companies. So it affects local and international companies equally. And in our case, we even have the interesting affidavit by a wholly owned South African subsidiary of a German company who says that they are being required under South African law now to do what is illegal to do under German law. So there are so many angles on this thing that I want to encourage viewers and just any businessman with sense in this country, don't get drawn into concessions that you don't need to do. If you get your first opinion from your HR staff and so on, also get a second opinion from NIASA. They've dealt with this. They have plans for dealing with this. And remember that you have 5 years to deal with this. So we're fighting this, Russell, and we've now appealed to the Constitutional Court and the Supreme Court of Appeal on this urgent interdict part. We're also continuing with our non-urgent application in the High Court. BUSA last week announced that they will be bringing an application.
Business Unity South Africa, a large business group.
Yeah, and they will bring it on other grounds, but that's great. It's, with the NHI, which we might get into later in this conversation, we already have 9 challenges against the NHI, and now we have 2 challenges against the Employment Equity Act. That's all a good sign. People sometimes ask, is it a good thing to have more than one litigant? It's absolutely wonderful because we have this wave of litigation. We're seeing an unprecedented wave of public interest, economic order litigation, and this is quite appropriate. And we're actually only getting started at Sakeliga, and I suspect in other quarters as well.
So on the employment equity, on that unfavorable decision that's now been appealed, we've filed that application for appeal. To the Constitutional Court and to the Supreme Court of Appeal. So that's now underway. That continues. And yes, as you say, the more stakeholders, particularly for something like the NHI, which requires really just holistic. It invokes and incorporates and implicates so many stakeholders, from hospitals to medical aids to medical suppliers to patients to doctors. And all those kind of broader interest groups, including Sakeliga, have launched very, very comprehensive litigation against it, which is a good sign. Okay, so employment equity, yes, a setback recently, but we continue to stride ahead confidently, and this is not something that can be accepted.
It's a multi-year effort, and let's just keep track on not doing business on a spreadsheet.
So we mentioned the NHI. We have filed case opposing the NHI. It's comprehensive. It invokes constitutional arguments. It looks at the extreme costs of the NHI. There's not much more to say about the substance of our case. We could get into some of that, but essentially this drives, something like the NHI drives right at the heart of your freedom to choose your profession, to contract freely with people for services. And there's several constitutional protections that it infringes upon, but also is simply going to cost and going to imply just completely unrealistic efforts from everyone involved. It implies 30-40% increases in taxes for people.
Yeah, let me ask you about that, Russell, because you actually spearheaded our economic research into this. We also got in some good people from outside, but we've built a very good case, which you were very much involved in. Tell me just a little bit about the cost, because the national government can't get the Ditsobotla functioning. We'll speak about that as well maybe later. But so much is falling apart, and now this mega project is being started. But we actually don't think it will ever succeed. But and people are quite right when they say that the NHI will never completely arrive. But the risk is something else. Just tell us about that.
So firstly, Piet, there's two things to say about the cost. The first thing to say is the cost itself, which is estimated anywhere from 800 billion rand a year to 1.5 trillion rand a year, which would, on the upper end, imply something like nearly a doubling of the government's budget. So that just requires just an enormous increase in not only in taxes but borrowing and potentially the temptation to print money down the line and all sorts of fiscal and economic havoc down that sort of road. But even if you cost it more conservatively at the sort of 800 billion rand a year level, it's just an absolutely enormous cost that is not currently provisioned for or budgeted for in the National Treasury's medium-term forecasts. No one's thinking about this in terms of taxation increases. So this is kind of fantasy world by the Department of Health, where the Treasury has kind of, somewhat kind of sheepishly said, this actually is just totally unaffordable. And, so there's clearly evidence of incongruity between sections of the executive itself around this. But the other interesting thing to say about the costing is that the state itself has not done a proper comprehensive costing of the NHI, believe it or not. They've, more than 10 years ago, gave some indications, some broad indications without comprehensive work, at least nothing that's been made publicly available. So there might be some behind-the-scenes work that's been done and not revealed to anyone. And one of the reasons why perhaps that's not been shown is just because of how
enormous
it shows the costs are. But we have not seen a proper, rigorous cost estimate from the state itself.
Yeah.
So that is just completely irrational and unreasonable to propose something without that has major fiscal implications and direct fiscal implications. This policy, the NHI, this legislation, implicates Treasury directly. Treasury has to set up a fund, a central medical fund, to pay for everyone's healthcare, and this has not been properly costed. But Piet, to finish this off, your question implies something very important. Yes, this is unrealistic. Yes, the NHI, as it stands in legislation, is impossible.
It's never going to happen.
It's not going to happen. But the damage comes from trying to make it happen. The damage comes from trying to do 5, 10, 15, or 20% of what the NHI envisages. That in itself is going to turn doctors and specialists away. It's going to disincentivize medical companies from investing and from building businesses and from providing value. It's going to wreak all kinds of havoc. The state already is in sort of pre-NHI implementation moves, is trying to regulate prices in the medical sphere. It's trying to control who can and can't supply various goods and services. And so this is something that absolutely has to be pushed back. And I think the key word here is not allowing the state to set the terms of negotiation for what the healthcare sector is going to look like going forward, by making a absolutely ridiculous opening set of demands, which is the NHI. If we use the NHI demands and proposals as the benchmark or as the anchor for negotiations, we're going to end up with a dysfunctional healthcare system. Wherever we're not going to get the NHI proper, but anywhere that goes close to that, we're going to have dysfunctionality in our healthcare system. And so we mustn't make concessions. We must push back hard, not only in the courts but outside the courts as well. There are plenty of stakeholders with tremendous amounts of authority and ability within the medical sphere to push back and to essentially decide that they're not going along with a fantasy.
They're not going to engage that opening offer.
Yeah. Piet, moving on to a place that we've been litigating for a long time, but very successfully so, is a place called Ditsobotla. Not many people have heard of it. There's a town there that some people would have heard of called Lichtenburg. This is in the northwest province. Lichtenburg and Ditsobotla municipality has been severely mismanaged by that municipal government. Sakeliga got involved there a number of years ago. That is a long story that we won't get into all now. But we've been having tremendous success in moving that municipality and moving things along towards resolving some of those problems. We've had some recent wins there, and just help people understand the core element of what's going on in Ditsobotla, because there's really some fascinating things that are going on there, including admissions by certain politicians in the Northwest that, frankly, this is not a situation that we're going to vote our way out of. Tell us about that, Pete.
Yeah, well, it's a story of multiple mayors, multiple speakers, of no water, no electricity, no municipal management, just a complete collapse of the state in Ditsobotla. And it's not a new development. It's come along for quite a while. And we had to work together with our partners who invited us to help them in Lichtenburg, good organizations like Agri Northwest and others. And it took multiple years of litigation to force first the province and then now national government to take on up the responsibilities of restoring order to that municipality. And the national government's been resisting this, and our recent success was building a good enough case so that we were able to force them by threatening them with cost orders. We notified about a month ago, 6 weeks ago, so we notified President Ramaphosa, Minister of Finance, Godongwana, Minister of Kokta, Klabisa. We let them know that we are now going to ask for personal cost orders if they do not take charge in Ditsobotla. And we had built a strong case for that, and I'm sure that they were advised that we were going to get that, because they had, by their own admission and by this gentleman's admission that you mentioned earlier, who said that it's no use voting for Lichtenburg to try and vote its way out of the problem. The province admitted, national government admitted that they are actually obligated to intervene, but they still failed and still oppose us in litigation. So this was the victory. It was building a strong enough case, having enough intermediate victories, and then finally threatening them with cost orders. So basically on the steps to the court, they've now given in, and they've now intervened. And so national government, Minister Godongwana, President Ramaphosa, they're now personally responsible for what's happening in Lichtenburg. That's not going to solve it. We don't think that this is a silver bullet, but we're going to give them a year, some time to show and make good on their promises. But given the state of the country, it's unlikely that they'll be successful. And then there will be a next phase of litigation, and that phase of litigation will be designed to empower the businesses and the communities in town to make alternative arrangements for the town to function in this circumstance of state failure and vacuum of authority.
And Pete, this kind of thing has just, people need to just remember that this has this very tangible, real world effects on all people who live in towns like this. Not just businesses like Clover who were once there and have left, but all the way down to people in informal settlements who get absolutely nothing, no services, no water, just
crime, roads,
crime, increases in poverty, just incredibly, just degradation. And
this happens all across the country. There are 200 municipalities, and what's happening there is important even also for the metros. We have to stymie the tide of town collapse, because otherwise we'll have a city collapse.
Yeah, and so that's critically important. So sometimes people might say, why are you spending so much time in this little place in the Northwest Province? But it's because of what it means and can mean for so many other towns, from the perspective of the processes that we're following, the lessons that we're learning about how to make progress to solving for the long term towns' problems. And just to crystallize the point finally, the Northwest Kokta MEC, where he said we're not going to vote our way out of this, essentially, he was essentially saying one option to try and fix the municipality is to dissolve the government and to have a new election. And he said that's not an option, because every time an election is held, the same parties and the same groups of people get elected and they cannot run. They continue to break the town. Now, that is very, very interesting and fundamental, and it says something very uncomfortable for a lot of people, that that this voting mechanism, that this local election mechanism is not delivering the good. It's not delivering what it's meant to deliver, which is peace, functionality, cleanliness,
flourishing society.
And so now you've got explicit admissions about that at this in this town, and that's not the only town that this applies to. And so really, what's going on here, Piet, is not just dry litigation, but it's how do we redefine the state's role when it comes to everyday political life in places like Lichtenburg and Ditsobotla, and what does that mean for 200 towns across the country?
Something's rotten about the political structure in South Africa, the way we think about governance. Too much reliance is put on the voting mechanism for solving problems, as if that is the only legitimate source of authority, as that is the only possible source of solutions. And as much as there's a place for voting, there's a place for democracy. I mean, there's been a place since old city-states of Athens, but those city-states of Athens, the Greek city-states, look very different from many countries today. And even South Africa's democracy, and even South Africa's local governance system and national election system, and even the way the country is structured, whether it's federal or centralized or unitary and so on. There are many different models. And I just think, Russell, that what we see, the admission of that MEC in Northwest, what we see there is the beginning of a recognition across the political spectrum that we need to be willing to reconsider the way in which we recognize authority in this country, and it also requires us to be willing to recognize competing and multiple sources of authority. And in our case, I think that businesses and business formations will play a crucial role in stepping into the vacuums of state failure over the next few years. And this is why we've said multiple times, and our role is not to change the government in charge. We're not there about deciding who is the government or one of the local governments. We are there to redefine the role of the state in society, because it's become unhinged and unbalanced. We need to restore a constitutional order, restore balance, and that's not giving politicians all the control.
Great, Piet. As let's bring this to a close. We mentioned at the start that we've got a comprehensive list of litigation. This year alone, we've had two very successful wins in the courts. The first one is the series of wins that we've been obtaining in Ditsobotla to move litigation along towards a resolution of those problems in the way that you very eloquently described now. But the second big win is something of a landmark in the sense that it represents the first big win in the courts against what we call the third wave of BEE, which is this very pernicious wave that's attacking businesses' ability to participate in the economy, really kicking up since about 2018.
It's about gatekeeping the economy.
Gatekeeping the economy and race restrictive policies in that respect. So we've had a good win there. Maybe just talk briefly about what we achieved in that win and some of the victories we've been getting in that sphere of BEE.
Yeah, in the air service licensing case, we were successful in getting a court order that says that the Air Service Licensing Council, which is a regulator in South Africa that says whether air service companies may operate. That's anything from passenger services to excuse me. That's anything from passenger services to vehicle recoveries to air ambulances, spraying crops, business. Anything.
Yeah.
The regulator explicitly required BEE participation as a prerequisite for getting an air service license.
Yeah, or renewing your license.
Your license. And we had that set aside, and there's an order now in place that frees all air services in South Africa to...
It's a strong, clear, and emphatic order. It's 1 page long.
1 page.
And it just goes straight to the heart of it. May not be done. This is unlawful.
Yeah. And this is the first of its kind. Last year, we did get something outside of the courts of a similar nature, not as strong, but it was in the case of the property practitioners, where the regulator there tried to make BEE participation a prerequisite for property agents, that's called a property agent, right?
Estate agents.
Estate agents, for property developers, for bond originators, for anybody who had anything to do with property.
Yeah.
And we got them outside of the court.
At pain of not getting a license renewal.
Yeah. You're not going to be allowed to be an estate agent if you don't participate in BEE.
Yeah.
And so what we then did was we put together a very strong court case. And we forced them, even before being in court, to concede that, okay, they will relax the requirements. They're only going to require you to have a BEE certificate, but you don't have to participate. Your score can still be 0. So you can be non-compliant on the certificate. Now, so that case is still progressing. But why I'm making this point is we're getting victories even outside of court by making strong court cases. And sometimes we pull that whole thing through and we get the court order and we seal it with a court order. That's also fine. So this year we've had 2 good victories so far, and maybe there's more.
Great. So we currently are. Let's summarize this. We've got 7 current cases in high court.
In high court right now.
Some of those we've discussed already. We're launching a new case this week, which is also a third wave BEE case, very similar to the Air Services Licensing Council case, but now looking at the International Air Services Council.
Yes, because what has been happening is that not only local air services companies, but also international airlines, like major international airlines, have been receiving letters requiring them to do some BEE. And that hasn't progressed, but still the threats are there.
The veiled threat is if you don't do this, you are potentially going to lose your license. To
there's
fly.
been some kind of penalization, license or no landing rights or something.
Even if it's implicit in these sort of threats.
So we will bring that case very soon. Then we'll have 8 cases concurrently in the High Court. Yes.
Okay, we'll soon have this week. We'll have 8 concurrent cases. We also have about 5 court cases in an advanced stage of development for litigation. What that means practically is the launching of several new cases before the year is finished and into the early part of next year. So it's conceivable that by the first or second quarter of 2026, we'll be, unless some cases fall off because of victories or those cases come to an end, we'll be sitting somewhere around 10 to 12 cases early next year.
We'll hit a dozen cases soon, and then we're not intending to stop. Like we said, we're in the early phases of an unprecedented wave of public interest economic litigation.
And then we have around about 25 cases not mentioned yet under investigation.
Yes.
These are matters, some of which won't all come to fruition. Yes. Some of those investigations will peter out into nothing too substantive. Yeah. But in other cases, that will then graduate into the case development phase. And so that's what this looks like through into 2026. So a lot on the go when it comes to Sakeliga's litigation. And Piet and I want to make an appeal that this, and a reminder that this is only possible with the help of our very loyal and committed supporters. Piet, we've been so encouraged this year. We have just had an incredible wave of support coming through for Sakeliga this year, from small funders giving 1, 2, 3, 400 Rand a month, all the way up to large funders who've decided that this is an important mission to get behind. Yeah. It's been incredibly encouraging, and I would like to encourage people that as great as it's been up until now, and as much as this has allowed us to scale up in the way that we've just described, we need to do much more, and we're going to do much more. And when people get behind us, when you get behind the Sakeliga mission, this is the kind of stuff that you enable for us to push back across various spheres and sectors, harmful legislation, harmful regulation, and not only that, not as just some performative exercise, but in a way that actually can achieve success. And we're seeing it across our various spheres of litigation.
Yeah, Russell, encouraged, as you say, we are very much by this, and we've just discussed litigation today. Our funders also enable us to do things, what we call alternative structures, We've been having good success with international engagements. The Ekurhuleni case is mentioned at the highest levels, not only in the USA, as it obviously would, but it's also brought to the attention of diplomats and foreign representation elsewhere. And similarly, our work in Ditsobotla, thinking about the future of businesses intervening, restoring economic order, that's all possible with the help of very encouraging support in recent years. So absolutely great.
Well, thank you, Piet. Thanks for your insights. Ladies and gentlemen, I hope you got great value out of this and got a taste of what we are doing here at Sakeliga and the areas that we are pushing back on. There are other entities and groups that are also doing great work. And together, this constitutes a kind of coalition of resistance against so many of these unconscionable and unacceptable policies. So thank you for your support. We look forward to journeying with many of you as you get behind us. And Piet and I are going to continue working hard to achieve good success in that which we're putting our hands to. Thanks and take care.